in a New York courthouse.
Okay, Mr. Ogden, everything checks out. We hereby grant you exclusive navigation privileges of all the waters in New York. Here you go.
Thank you very much, sir.
In a federal courthouse.
Alright, Mr. Gibbons, looks like everything is in order. The United States Congress hereby permits you to operate on waters between New York and New Jersey.
Thank you.
Sometime later.
Hey, I saw you piloting a boat down one of my rivers the other day.
Your river? I have just as much right to be on them as you do.
You just think you do. Look here, I legally have exclusive rights of navigation on these waters.
Well, I guess those rights aren't as exclusive as you think. I have permission from the United States Congress to operate on these waters.
That doesn't matter. We are in New York. The state has control of what goes on within its borders.
Well, even if it does, I'm not going to stop my business. I have a right to operate between New York and New Jersey.
Well, I'm gonna sue you for violating my exclusive navigation privileges. Then we'll see who's voting on whose river.
Fine, I'll see you in court.
A few days later, in a New York courthouse.
The prosecutor please stand and deliver his case.
With pleasure, Your Honor. The defendant, Mr. Gibbons, has violated the monopoly over navigation rights within the borders of New York, issued to myself by the New York legislature. States often pass laws on issues regarding interstate matters, and states should have fully concurrent power with Congress on matters concerning interstate commerce. Therefore, I ask the court to restrain Mr. Gibbons from operating on these waters.
Will the defendant please rise?
In my defense, states do often pass laws regarding interstate matters, but Congress has an exclusive national power over interstate commerce, according to Article 1, Section 8 of the Constitution. And to argue otherwise would result in confusing and contradictory local regulatory policies.
Several hours later.
The Court of Chancery of New York and the Court of Errors of New York have found in favor of Mr. Ogden and issue an injunction to restrict Mr. Gibbons from operating his boats on these waters.
This isn't over yet.
March 1824, in the Supreme Court, held by Chief Justice John Marshall.
I have appealed to you, the Supreme Court, because the monopoly held by Aaron Ogden in New York over navigation conflicts with federal law.
Okay, Mr. Gibbons, on what grounds does it conflict with federal law?
Well, glad you should ask. According to the Commerce Clause in Article 1, Section 8 of the Constitution, Congress has exclusive national power over interstate commerce. By issuing this monopoly over navigation privileges in New York, the state has violated Congress's exclusive power over interstate commerce.
Objection! The Court of Chancery of New York and the Court of Errors of New York have already determined that the states have equal power to Congress on matters concerning interstate commerce.
Several hours later, yet again.
We have reached a verdict. The Supreme Court rules in favor of Mr. Gibbons. Commerce is more than mere traffic. It is also intercourse. This includes navigation. Also, any license granted under the Federal Coasting Act of 1793 takes priority to any similar license granted by a state. Court is adjourned.
Ha! Told you it wasn't over. I win.